Hello everybody and welcome to History Bite number 109, dated November 14th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The Constitution of the Confederate States of America. Many people, many Americans specifically, do not realize that the Confederacy, aka the Confederate States of America, the Union's opponent during the American Civil War, had a fully functioning written constitution. I mean, why wouldn't they? They wanted to be recognized internationally as a nation, right? Indeed. For sure, when the initial southern states seceded from the United States after the election of President Lincoln in 1860, these states organized and formed a new country known as the Confederate States of America. All right? With that in mind, they adopted a written constitution. That document, for all intents and purposes, was a word-for-word duplicate of the United States Constitution. I mean, that's all they knew, and they learned from the best. Okay? C'est la vie. The authors of the Confederate Constitution learned from the U.S. Constitution what they wanted, which was virtually everything, but the Constitution of the Confederacy definitely had its own nuances with respect to language and a few other things as well. The Confederate Constitution, unlike the U.S. Constitution, definitely has its own specifics. For example, the Confederate Constitution specifically invokes the protection of Almighty God in its preamble. And additionally, in the preamble, we see a specific emphasis placed on states' rights and the independent nature and character of each state. I'll read it to you if you don't believe me. It goes as follows. We, the people of the Confederate States, each state acting in its sovereign and independent character, in order to form a permanent federal government, establish justice, ensure domestic tranquility, and secure the blessings of liberty to ourselves and our posterity, invoking the favor and guidance of Almighty God, do ordain and establish this Constitution for the Confederate States of America. That is the preamble. Sounds just like the U.S. Constitution's preamble. And indeed, that's what it was drawn from. But like I said, they directly invoke the protection of Almighty God and place a very specific emphasis on states' rights. That's not present in the U.S. Constitution. Neither one are. All right. Unfortunately, the U.S. Constitution and its preamble do not contain a reference to Almighty God, although in my opinion, it should. All right. You can fight me on that one later. Okay. So, like I said, the framers of the Confederate Constitution more or less incorporated all of the language from the U.S. Constitution into their own Constitution, though, like I said, with occasional polishing and sawing off of things and tweaking of things that they felt perhaps were obsolete, outdated, or not exactly germane to the message that the Confederacy was putting out there to the world. All right. So the Confederate Constitution contains no amendments. Indeed, Amendments 1 through 12 of the U.S. Constitution and their language in general was incorporated into the basic body of the Confederate Constitution. All right. So you will find the Bill of Rights, the U.S. Bill of Rights, incorporated into the Confederate Constitution in Article 1, Section 9, Clauses 12 through 19 of the document, okay? And Clause 20 of Article 1, Section 9, unlike the U.S. Constitution, requires bills passed by the Confederate Congress to have a single subject. That's definitely not required for the U.S. Congress, okay? A primary difference between the U.S. Constitution and the Confederate Constitution as well is the Confederate Constitution's, make no mistake about it, protection of slavery. The U.S. Constitution, in my opinion, this is just my opinion, somewhat dances around the subject and loosely protects slavery as an institution. Okay, it doesn't speak in great lengths about slavery, and that was the deliberate intention of the framers. Okay, as a matter of fact, the framers of the U.S. Constitution took great pains to avoid the discussion and adding the word slave or slavery to the U.S. Constitution only when absolutely necessary. Okay? But the authors of the Confederate Constitution didn't want anybody to think for a single second that this Constitution did not recognize slavery as a constitutional right. Indeed, the Confederate Constitution made sure that everyone in the Confederacy and indeed in the entire world who bothered to read this document knew that slavery was a protected right under the Confederate Constitution. All right? So for all of you out there, all folks who say that the Civil War was not about slavery, my suggestion to you is that you simply read the Constitution of the Confederate States of America, and your opinion will change very quickly. All right? So we see slavery protected in numerous provisions in the Confederate Constitution. Article 1, Section 9, Clauses 1, 2, and 4 definitely protect the institution of slavery. All right? I'll read them to you real quick. Section 1 says the importation of Negroes of the African race from any foreign country other than the slaveholding states or territories of the United States of America is hereby forbidden, and Congress is required to pass such laws as shall effectually prevent the same. Okay? Number 2 says Congress shall also have power to prohibit the introduction of slaves from any state not a member of or territory not belonging to this Confederacy. And number 4 says no bill of attainder, ex post facto law, or law denying or impairing the right of property in Negro slaves shall be passed. All right? So the Confederate Constitution makes it quite clear in those provisions that Congress is supreme in regulating slavery, but no law denying or impairing the right of property in Negro slaves shall be passed. Okay? Article 4, Section 2, Clause 1 of the Confederate Constitution specifically protects slaveholders traveling throughout the Confederacy with their slaves, and it prohibits both the Confederate Congress and the states from impairing the right to property in slaves. So like I said, make no mistake about it, slavery was a die-hard, very protected constitutional right in the Confederacy, and it is recognized as such in the Constitution of the Confederate States of America. Again, the Civil War wasn't about slavery? Think again. More differences from the U.S. Constitution is that Article 2, Section 1, Clause 1 states that the president and vice president shall serve a 6-year term, but the president is not eligible for re-election. Vice president can be re-elected, but the president is not. So he serves a single 6-year term, and that's it. He's out the door. Of course, at this time, the U.S. president could be elected an indefinite amount of terms. All right. Article 1, Section 7, Clause 2 of the Confederate Constitution also gives the President of the Confederacy the line item veto, something that the U.S. President does not have. All right. Article 3 of the Confederate Constitution provides for the creation of a Supreme Court and a lower federal judiciary if the Confederate Congress wishes to do so. Interestingly enough, the Confederate Congress never created a Supreme Court or lower federal judiciary for the Confederacy, likely out of fear that the Supreme Court of the Confederacy would follow the example of the U.S. Supreme Court and impose massive amounts of federal power, okay, over the states, something that just was absolutely unacceptable to the framers of the Confederacy. I mean, they had just left the Union out of fear of too much federal power. So why would they want a Supreme Court basically continuing that tradition? So the Supreme Court was never created for the Confederate States of America. Okay, all litigation in the Confederacy was handled in the individual state courts in the Confederacy. All right. More differences. Article 5, Section 1, which of course in the U.S. Constitution is the amendment process, it is also the same in the Confederate Constitution. But Congress is not empowered with the ability to pass amendments and then send them to the states for ratification. Indeed, in the Confederate Constitution, amendments can only be proposed by way of a convention, which can only be called by the states. The convention can be called by the Congress of the Confederate States of America upon the application of no less than 3 states. So 3 states would have had to petition the Confederate Congress to call a constitutional convention, whereby at that point proposed amendments to the Confederate Constitution could be proposed. Okay. Once those amendments were proposed, a marked difference here from the U.S. Constitution, only 2/3 of the Confederate States would need to ratify it for it to become an operative part of the Constitution of the Confederacy. You know, in the U.S. Constitution, you need 3/4 of the states to ratify. So the Confederate Constitution makes the process much easier than the U.S. Constitution. So 3 states were needed to petition the Congress to call a convention where amendments could be proposed. And at that point, any amendments that were accepted by the convention and sent to the states would only need to be ratified by 2/3 of the states. So the amendment process for the Confederacy was much simpler than in the U.S. Constitution. And last but not least, Article 7 of the U.S. Constitution only required 5 states to ratify the document to bring it into existence. Okay, so that's a definite difference from the U.S. Constitution, which required 9 states to ratify to bring it into existence. All right. Now, at the time this Constitution was written and came into effect on the 11th of March, 1861, there were only 7 Confederate states. Okay, additional Confederate states would join. All right, later on, after the Confederate Constitution was written and came into effect on March 11th, 1861. The following states would join the Confederacy: Virginia in April of 1861, Arkansas in May of 1861, North Carolina, May of 1861, and Tennessee in June of 1861. All right. So the Confederate states that proceeded to draw up this Constitution, that sent delegates to do this, were South Carolina, Georgia, Florida, Alabama, Mississippi, Louisiana, and Texas. All right. And again, folks, these are just some examples of the differences between the U.S. Constitution and the Constitution of the Confederate States of America. Certainly the Confederate Constitution borrowed heavily upon the U.S. Constitution. Like I said, it's almost a word-for-word duplicate, but it has its own nuances with respect to the language and procedures of things. And it arguably updated certain things to be in uniformity with the times, okay, such as streamlining the amendment process, okay. The primary downfall of the Confederate Constitution, something many lost causers are in denial about, is the fact that the document, beyond all question, protected the institution of slavery virtually against any legislative encroachment of any kind. All right. So that is the Constitution of the Confederate States of America, folks. Look it up for further details. All right. It's a very interesting read. All right. Any questions or controversies with this, please leave them down below. I'll be happy to answer them. If you have not subscribed to my YouTube channel, I would most graciously appreciate it if you did so. Take care. Stay safe out there. And I'll talk to you at the next History Bite. Peace.